about the lack of shelters or help for homeless in.
Please stand for the flag salute.
She was way ahead.
Of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I just mean.
Good evening, ladies and gentlemen. Pursuant to applicable portions of the New Jersey Open Public Meetings Act, adequate notice of this meeting has been given. Notice of this meeting was posted in the Township website and was published in the Asbury Park Press. In accordance with board policy, this meeting will commence with consideration of administrative matters that do not require a public hearing and to caucus on applications which have concluded their respective public hearings. During the portion of the meeting, members of the public may listen to the discussion, but may not participate unless permitted by board chairperson. The board will then proceed to hear matters scheduled for public hearing. During these hearings, members of the public or their attorneys may, as permitted by the chairperson, ask questions of the applicant and any witnesses produced by the applicant. Following the presentation of all evidence, members of the public will be invited to make statements regarding the merits of the application. Please note that if you choose to make any statement or produce any evidence in support of or in opposition to any matter, you will be placed under oath and may be subject to cross-examination by the board, the applicant, the objector, or their respective attorney. Please note that following the public hearing and prior to the adjournment of tonight's meeting, you will have the opportunity to address board on any matter during the public comment portion of the meeting. Roll call.
Mayor Robert?
Here.
Nick Pascarella?
Here.
Nick Bradley?
Here.
Kevin Fennell?
Here.
James Bradley?
Here.
Bob Watson?
Here.
And Joe Lizardo?
Here.
7 members present, we have a quorum.
Our first order of business is a public hearing on the housing element and fair share plan of the Township Master Plan.
Good afternoon, Board. Or I guess good evening. Good to be before you again. I was last before you in June 2025. My name is Chris Rizziano. I'm from the law firm Reno, Coughlin and Cello. We serve as Affordable Housing Council to the township. So I'm going to take us back just to review the history of how we got here, both for the benefit of the board as well as the public. I think it's important to understand the historic the time frame by which municipalities like Toms River are operating. In 2024, the legislature passed a bill called the Amended Fair Housing Act, which amended the structure by which municipalities need to comply with their Mount Laurel obligations throughout the state. In 2025, January 2025, municipalities across the state entered into what is known as the Affordable Housing Dispute Resolution Program. And the design of the program was to do two things. Determine what your fair share obligation would be, the municipality's fair share obligation will be for the foreground of affordable housing obligations that run from 2025 to 2035. The second item, after establishing what that fair share obligation would be to review the town's compliance plan for how it would provide the necessary opportunity to capture what's called the regional need for affordable housing. Your region is comprised of multiple counties. It's not just Ocean County, it's not just Toms River. In January, the township entered into that program, and by doing so, received what's referred to as automatic immunity from builder-owned lawsuits in the course of its participation in the program. In this early spring, the court established what the township's obligation for the fourth round would be, and that number was 649. So that is, the township has to find a way to, in some way, provide the opportunity for the construction of 649 affordable units from the present day through 2035. In June 2025, the township submitted a plan that would provide its mechanisms to do that. What's really important in this case is because it informs why we're here with sort of a more complex package for consideration. Complex, I just mean that there are modifications from June 2005. The township was engaged in litigation with a nonprofit entity called Fair Share Housing Center. They've been in this game since the 70s. They've had a seat at the table, and in fact, the court automatically, by law, gives them a right to sit at the table of any municipality's litigation concerning affordable housing obligations. They're considered an interested party. At the time that in June 2025, when the planning board adopted its fair share, its housing element and fair share plan, the township was engaged in litigation concerning the third round, and what's called, I'll call it carryover obligation. So the township is arguing that we are entitled, the township is entitled to cap its third round obligation and move those units into the fourth round. Fair Share Housing Center is arguing that, well, historically, we believe that, in fact, the township owes an additional obligation on top of its third round obligation in the thousands. And the idea was they were arguing that we should provide during the fourth round not only 649 units, but an additional 1,000. And it's a very significant number, far over 1,000, which should be placed on top of the 649. Under the statute, after June 2025, there's a 3-month period by which challengers, whether that be developers or nonprofit groups or Fair Share Housing Center, can come in and challenge the plan. And throughout the state, Fair Share Housing Center and developers sue municipalities. Picking out nitpicking plans, or trying to go after large elements of the plan. In the township's case, Fair Share Housing Center, as it did throughout the state, filed a challenge, and 3 developers also filed challenges. By filing a challenge, you have the opportunity throughout the course of this fall and winter to argue the court why the plan is not consistent. So, from June 2025 through to December, the township was engaged in several conversations through this mediation forum and program to try to figure out how it could come up with a plan that would satisfy some of these objections. What's important is that during this process, the township was able to reach a resolution with Fair Share Housing Center that enabled us to get rid of the 1,000 extra units from the third round and stick with our 649 unit obligation. Why is this all important? Why is all this framework important? In June 2025, the plan that we had before you provided mechanisms in light of the argument that there could be units in the third round into the fourth round because of the cap. Because of our argument that we can cap our third round obligation. The settlement that was adopted and approved by the Township Council in December 2025 modifies the compliance structure, and I'm going to walk through that very briefly so that you have an idea of what's now in the amended housing plan. What needs to be done before March 15th, pursuant to the statute, is that a municipality needs to adopt any amendments to its housing element and fair share plan, and it needs to enact all the zoning, all the mechanisms that will make possible all the zoning that makes possible mechanisms in a housing element and fair share plan. If the municipality doesn't do that by March 15th, unless otherwise given more time, the municipality is at a risk of delivering lawsuits brought by developers. So, I want to run through the modifications to the plan so that you understand the settlement agreement that was adopted, approved by the Township Council. So the first item is, I'm going to refer you to page 7 of the housing element and the amendment to the housing element and fair share plan. But what the chart at page 7 does is incorporate the plan that was included in the settlement agreement approved by the council. So, first I'm going to identify all the mechanisms that remain in the plan as originally presented, and that is one of the critical items this township constructed this plan around is the preservation of existing units in town through what are called extensions and controls. So basically, the amended FHA not only recognized that the creation of new units was important, but the preservation of units was also important and a critical mechanism by which the council is working.
Yeah. Mike's not on.
All right, how about that? Okay. So as I was saying, the amended FHA provided for the preservation of existing use in town through a number of different mechanisms, one of which is the extension of deed controls on existing parcels. So I'm going to identify mechanisms that have remained the same since June 2025. We have Highland Plaza, which is an extension project to preserve existing affordable units. Woods at Massachusetts, Villages at Bailey, North Point, I'll pause there. North Point is a existing mechanism by which the township is going to secure extended controls for residents. In December 2025, the HMA released new regulations that will govern this process. So there's a time at which there is time that we need to be able to review documents, review regulations, to make sure that all the documents are in place. And this applies to all our extension projects. The next is the Cooper Claudina redevelopment area. We were modifying the plan to just be able to provide the opportunity for 6 more affordables. And now I'm going to move because the last item is Holt's Crossing, and we'll get to that in a moment. The new mechanisms, and I'll explain each one so you have context to understand why they're in the plan. First is Jamestown. Jamestown is an existing project. They were a challenger during the affordable housing process. They had a seat at the table to challenge the township's plan. The settlement agreement provides for additional units at the Jamestown project, which provides a substantial number of units that can go to fill your plan and what is frankly a very large obligation, 645 units. So that's a new item, and before you is not only housing element which includes that project, but the zoning is before you today for a consistency review. The second is 2008 Route 37. This is also a challenger to the housing element and fair share plan. They participated in the program, and the settlement for that project was the authorization to build 2 floors on top of existing commercial to capture affordables on top of the existing commercial. The footprint of the building does not change. The last inclusionary housing project was Route 70. So the township was presented a need to capture affordables in as many ways as possible. Obviously, one of the critical elements is the use of preservation. In preserving units in town, you can't simply just say we're going to preserve units. You have to make monetary contributions toward that preservation. So there's monetarily, there's a finite number of preservations you can actually do. Two, there are a finite number of projects that have enough existing housing units that are deprotected that are going to come due during the 4th round that you can extend. Simply because a single-family home has a deed on it doesn't mean that you can extend during the 4th round with credit. There's only a finite number of units you can actually utilize. So, in constructing your plan, it was necessary to try to find other mechanisms to meet your obligation. Route 70 is a rezoning of land along Route 70 that will mandate the developer provide affordables through a set-aside. We've done a 20% set-aside, which is customary throughout New Jersey, and it's one of the only numbers you can actually get in litigation and succeed on. So we didn't lower it, we set it 20%. The last item is Holt's Crossing, which is also preservation. I'm going to stop there because there's one element of this housing element that I need to draw your attention to. Hope's Crossing is also a preservation project. There, the developer has thrown up roadblocks and asked for more than what was promised them. And so to deal with that, what we've been able to do is pursue a supplemental project, which is a 100% affordable project on parcel owned by the township on Route 9. And that is a way of trying to get around this developer's obstinance in order to still satisfy our budget deadline and present enough units to satisfy the units that were going to be divided by Hope's Crossing. What we're looking to do is adopt a housing element convention plan that recognizes the plan, recognizes the defined structure from the settlement agreement, and also provides the township the discretion to use the Route 9 project should it need to fill the gap of Hope's Crossing. Just to lay out what will happen after today, provided the housing element convention plan amendment is adopted, it will be presented to the Township Council for ratification, and then provided to the court in order to show the court and show any other parties that we have met our March 18th deadline to protect ourselves from exclusionary zone. I'm going to turn this over now to the planner, some additional comments on the parcels. And then if there are any further questions, I'm happy to address them. Unless you'd like me to stop there and answer questions.
So one question. What happens if we don't have a compliant plan deadline?
Sure. So this is what these all term is like a up at night. So what happens is if you, this is, I don't want to go too many weeds, but since the 80s, such a mechanism was created by the courts called the village remedy lawsuit. The village remedy can be brought by a developer who has land in the town. They can bring that litigation if they believe that the plan and the zoning code does not provide for the ability for the town to meet its obligation. The village remedy is using two parts. One, the builder needs to show that the plan is not compliant. In other words, the housing element hasn't been adopted and the zoning is not in place. If they succeed on that, which can be done if there aren't those two elements in place, they then have the opportunity to show that their project can fill the gap. And if that gap's large, well, then that project can fill that gap. And what is so effective about these builder remedy lawsuits is it takes the zoning, control of the zoning out of the township's hands. And so that's something that we are always trying to protect against. And that is the purpose of the program, is to provide temporary immunity while you develop your plan so that all townships can get to the March 15th deadline. And there are municipalities meeting all throughout this week, and all throughout all throughout the last 2 weeks to try to get to that deadline. But exclusionary zoning can be brought by any developer or contract purchaser that has any intent.
One last question. Are there other opportunities along the way after the plan is accepted by the court to amend the plan? Should there need to be changes? Should projects drop off? Things of that nature? Should someone all of a sudden not have the means to complete a project or pull out of a project? Do we have opportunities at later dates to adjust the plan?
Yes. So the way the mechanisms work is that you have an opportunity to go to the court and ask for an amendment to the plan. What you need to do is you need to amend your housing element and fair share plan and make sure that your zoning is in place. So it's throughout the 10-year process, you have the ability to modify your plan to show that you're creating the opportunity for the ability to capture the affordable housing.
So if one of these developments, let's say, bought the land out from underneath literally, we could go out at a different time later on and find a replacement project.
Yes, and as long as you can show that there is an opportunity elsewhere to do that, and that it's realistic, then yes. Thank you.
Good evening.
Good evening. Richard Hunt, PPASCP, planner for the Lima Group and your township and affordable housing planner.
you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
And just identify yourself, please.
Richard Hunt, the Limo Group.
Thank you.
So good evening, Mr. Chair. Thank you for having me. Chris gave a very thorough explanation of how we got here, the mediation agreement, the new law, and everything. So I will keep it very specific to the actual units themselves and the sites. So I think it's important to note for the record that adopting this housing element and fair share plan gives the township control over their affordable units in the township versus the builder's remedy that Christopher was talking about. And of these 649 units, the township, through the amendment of FHA, you're able to seek a number of bonus credits through the different mechanisms. So one of the largest ones is our extensions and controls, which we have of the 649, 178 of those. So these are already constructed units within the township and keeping them affordable. And the state does incentivize this by offering a 1-to-1 bonus. So you are getting a number of bonuses through that. And then we have the Hopes Crossing development, which would be marketed to affordable conversions. Sorry.
Continue.
So the market to affordable conversions, those are 110 units. So these are already existing units again that would be converting into affordables. So again, these are already constructed units within the township, would be no new builds. So out of the 649, there will be 487 new affordable units. Those contain the extensions and controls and the Hopes Crossing as well, with 162.25 bonus credits. So I just think that's important to note for the board and for the public.
I think you have, I think you're flipped on the numbers. Yeah, am I correct? The extension and controls is the bigger number.
Yes, that's 178 units of extensions and controls. And then on top of that, there are 110 marked to affordable conversions.
So that's like 280.
Yes.
There's more somewhere. Hang on, sorry about that.
Just want to explain one element. The characterization of Hopes Crossing as market to affordables is a legal technicality because of the time in which those deeds existed. They're effectively affordable units that would be preserved as affordable units. It's legally used to recognize their deed status, but effectively they are affordable units that have been treated by the developer as affordable units past their deed control period.
Okay, I just
That's
want to know
the attorney's
You've been
making
saying it one way for the people of the town, and I don't want anybody to be confused about the level of new construction. Thank you.
Thank you. And so out of these, we have 186 new affordable units within the township out of 649. So a smaller percentage. So our compliance strategy includes, like I stated, the extensions and controls, inclusionary developments, redevelopment opportunities, market to affordable conversions, and as a supplemental mechanism, the municipally sponsored affordable housing site. We have the 2008 Route 37 site, which is a challenger. Again, this is a mixed-use development for affordable units from this site. Jamestown Village, a challenger. This is an existing residential complex. A number of these 14 of these units are existing, which will count towards ours, and they'll be converted to affordable, and there'll be 28 new constructions there. We have our Route 70 Beacons Estates. That's a inclusionary development, 134 affordable units. And then we have the Route 9 township-owned property, again, as a supplemental mechanism. And as part of the amended FHA, or the FHA in general, all these sites need to be reviewed for site suitability. So that's things like access and frontage, ownership, any environmental constraints, and infrastructure capacity. And each of these sites is located within the source service area and the state planning area too, which makes them appropriate locations for affordable housing development. Along with the Fair Housing Act requirements, you have to have a minimum 50% family housing, minimum 25% rental housing, a maximum of 30% age-restricted housing, and a bonus credit cap of 25%. And the township's amended plan complies with each of these requirements. Along with the Housing Element Fair Share Plan, there's an associated affordable housing trust fund. The township collects a number of development fees through any new development in town, commercial, residential. Puts these funds in the trust fund that they can use then for essentials and controls, affordability assistance, township purchasing properties, things like that. And that's all outlined in the appendix. There's the spend plan in the appendix. So that really sums up the sites that we have for the amended housing plan.
I actually have one legal question, and I'm really asking it just to point it out to the folks who are at home or the folks that are out in the audience. As far as the supplemental area that we're talking about on Route 9, wouldn't that require a vote to put anything there? Like to having, because the township owns that, the council, the planning board, things like that, there would have to be other votes in the future if a project were going to be put there, correct?
I'll defer to the attorney.
Just to clarify on the supplemental component.
Great, so what I hear is that the township owns the land that's in the Route 9 district. So that means that if there was, that township controls that land, which controls the development rights of those parcels. So there would certainly need to be township action to address any development in that area.
So it's a failed safe, should something fall.
Sure. That's a fair way to describe it.
Thank you.
Does anyone of the other board members have questions? Christine, Ms. Waters, do you have any questions?
I don't have any questions.
At this time, I'll be opening up to public comment. Please come forward, state your name, and spell it for the record. And whoever you're being sworn in.
Hold on, I just want to explain why I'm swearing everybody in. Planning board is a quasi-judicial board. It's not like going to a council meeting. So when you are up here, whether you're asking a question or you're making testimony, it lacks credibility if your testimony is under oath. Okay, so I just want to make sure everybody understands why I'm swearing in. Okay, so swear to tell the truth, whole truth, and about the truth.
I do.
Please state your name and spell it for the record.
Michael Messina, spelled M-E-S-S-I-N-A.
Thank you, Mr. Messina. Continue.
So, to start with, the mayor's given us a lot of time, a lot of his personal time, and several of the councilmen have come to Lake Ridge, the community where one of these developments, the plan to the state encompasses lot adjacent to Lake Ridge. And as an example, I know all the people here. I'm just going to do something just for the sake of it. Lake Ridge residents, raise your hand. It's the room. Okay. So we're here because we'd like to let this group of distinguished people understand where we are coming from. Now, I know that the state has mandated to the townships, we all understand that. The mayor's made that very clear. And one way or the other, we need to do this because the ramifications of having a builder's solution is very negative for the township, to say the least. Everyone understands that. And the last thing that Lake Ridge would like to do is to get in the way with the process with the state. You can't, you shouldn't do that. So one of the things and why we're here today is a plan was submitted, and the plan encompasses our egress and entrance on Massachusetts Avenue and Route 70, which is the third most lethal intersection in the state of New Jersey. In the United States, too. I wasn't going to go that far, someone said it behind me, but I know it to be a fact in New Jersey. And the idea of putting 600 houses within 300 feet or 400 feet of this deadly intersection is a primary concern to all the residents. Now, let's be honest. No one wants any more houses near them. We get that. But the rationale here about choosing a site that's near the third deadliest intersection and add even yet more traffic there is befuddling, to say the least. Now, the mayor has explained in great detail. This is the first step. The plan gets submitted to the state. The state essentially says you have fulfilled your obligation. And then, as the mayor said, things can go awry after that, certainly. You may not be able to buy all the parcels of land. The builder may pull out. There's a whole host of things that can happen. But an evaluation of the impact, both from the structures that we have in place, electric, gas, sewer, and such like that. I know that has not been done yet. And the mayor's assured us that that is part of the process and that will be the second step. But at some point, the overall safety of the community is really why we're here. Of course, we don't want houses built in our backyard. We don't want that. Of course we don't. But the safety factor alone, I would hope, would be significant enough for the next step when the council has to vote on it, or after the fact that it's approved, so that we can fulfill the state's requirement, that there would be an opportunity for alternate sites to be looked at because of this deadly intersection. And that's pretty much why we're here. And again, being upfront, nobody wants additional housing anywhere. But in this case, this intersection is literally a death trap. Why would we put 600 houses, which could equate to 900 or 1,000 more cars, into an intersection that's deadly, plus the fact the entrance and egress from that is close to the intersection? The proximity alone is not going to allow for safe maneuvering onto Route 70 or off of Route 70. That's really why we're here. So I know that this is a zoning meeting, and a vote will happen to change the zoning to comply with the state, and we get that. But we're hoping for the opportunity at the next level or the next level after that for this, our considerations to be heard, since fatalities happen there all the time. That's pretty much it.
Thank you very much.
Okay, thank you.
If anyone else would like to come up and comment, please come forward.
Hi, my name is Daryl Bossio, D-A-R-Y-L-B-O-S-S-I-O.
Raise your right hand, please. Swear to tell the truth, whole truth, nothing but the truth.
I do.
So spell your last name again, please?
B-O-S-S-I-O.
Thank you.
Okay. I'm a master gardener, so one of my concerns is naturally maintaining free land and open space and protecting our water and soil supply. That's one of my concerns. Another one, I question that why cannot we use existing housing or hotels or that has been closed, or offices, buildings that have been closed, that we can reconstruct and make housing affordable for the people, and this way it wouldn't hurt our extensive infrastructure, which would be creating by using new open land.
We did do that. The largest portion of our affordable plan is very unique across the state. It basically is extension of control for making a unit affordable for another 30 years. So these units have expired. So units that were built 3 rounds ago in the first round, they all expired this year. And what we did is we had $9 million in a trust fund tax that came from taxes not on residents but on developers over the last 30 years or 10 years, whatever it is. There's $9 million in there. We used that to extend the restrictions, make units affordable
For the
that
existing
are
housing.
already existing. So that is the vast majority. And what we did is we did every unit we could, every single unit we could. And then you're left with still having to make up that extra 180
And does
something units.
each community have like a quota, a maximum?
Yes.
They do.
Yes.
And is that maintained for the next 10 years also?
Yes, it'll be for 1 decade, and it'll be a decade to complete it. When we first got in, one of the first things we had to do in the first year was also make sure that we tracked down all of the information about the stuff that was built. Because it's difficult too to keep records of what was completed, wasn't completed. There were projects in the prior round that were never completed either, and that got calculated into our number as well. Does that answer the question, or did I get a little off?
Yeah, it pretty much does. I just hope we could keep some open land and not that we're all like the asphalt jungle.
You know, we love that, and that's the purpose of this plan. If we didn't do these deed restrictions, if we didn't go out and purchase that, we would have had to build many, many more units and thousands to fulfill that 600 or
Is it
700.
required that you have to build new housing?
I would love to answer that in a different setting. As far as like the negotiations, that was part of the negotiations that I'm going to leave that to the lawyer. I don't want to make that mistake. Go ahead.
I'll try to keep it simple, because I like this a little too much, and I tend to get a little too into the weeds. But, so,
Could you speak up, please?
Can't hear very well.
Can't hear you.
so
Very muffled.
basically, you have an obligation, and there are certain municipalities in New Jersey that are fully developed, small boroughs, small villages. There are exceptions for those type of municipalities to claim what are called vacant land adjustments. They perform vacant land analysis, and in those instances where they can show that there's no land to develop, there is a special mechanism by which they can delay having to actually identify specific projects and just create zoning. That creates a potential possibility over the 10 years that maybe we'll capture affordable. Municipalities like Toms River, they're not in that boat. You can't claim the benefit of a vacant land analysis. And so then, yes, you do have to find actual mechanisms. And so one way to try to do that is to use funds you have to deed restrict existing projects through extensions under lots of different criteria. Or 2, you commit to new construction projects somewhere. So it's unfortunate in a municipality where you are blessed with land that's open. Unfortunately, that's also a crutch when it comes to affordable housing. It's a complicated system. But the type of ability to just use overlay zones and walk away is something not available to municipalities like Township.
Because it's so large.
Because it's so large, because of the developable space. But particularly the size and its influence within the county. And by that I mean its demographics, its size, all those factors get added in.
Okay, thank you so much. And thank you, May. I appreciate everybody here and hopefully helping us to maintain the quality of Toms River. Thank you.
Thank you for your comments.
You can raise your right hand, please.
Yes.
Swear to tell the truth, whole truth, nothing but the truth.
Yes, I do. My name is Janet Lang. My last name is spelled Laing. And I just have a couple questions for the attorney. Can you tell me if my impression of what you've told me is correct? That the deal that was negotiated with Hope's Crossing is, for some reason, not going to be executed? And that is why we now need to take 10 acres of land that the township owns and has preserved for open space and potentially allow it to be developed. Because we're losing units that you have to fulfill in the affordable housing plan. Because of the Hope's Crossing deal not going through.
Would you be comfortable running through all 3 questions so I understand all 3, and I'll answer all of them at once?
You want me to do all the questions I heard?
You have 3 questions, correct?
No, I have multiple questions.
If you could just present me multiple questions, then I'll answer them.
Okay. They're not all on the same topic.
Okay. So Hope's Crossing, there was a disagreement, or there was a contention by the developer that they did not need to meet regulations provided by the state. And they stuck by that position, and so to protect the municipality, it was necessary to identify an alternative mechanism. That's not the Route 70 project, it's the Route 9 project. That is where we're at.
So that, the consequence of the Hopes Crossing portion of the plan falling through is not the result of the changing to the zoning on the 10 acres of,
No,
it's
so
not causing.
when you refer to the 10 acres, are you referring to the Route 70 project?
Well, it's near Road.
I'm just going to ask for that, just so I understand when you refer to that. I just need to get it.
It's the 10 acres approved.
It's the 10 acres owned by the property, or by the township.
Right, and you see your question, you repeat the question all the time.
So is the reason that that property is now being considered for development in the future the result of the deal not going through with Hopes Crossing?
Or do you want him? I think I was just going to clarify. Go ahead, you go
Yeah,
first.
I'll let you first.
You do your thing, go ahead.
Yes, the Route 9 project was a way of protecting the township because of the developer's position that they did not need to comply with state regulations.
Can you explain which regulation that is about the 60% versus 80% of our
That would be
operating?
wonderful. I would appreciate that.
Sure, okay.
I don't mind the weeds.
So the state regulations provide that units that are moderate, let's say moderate income units, can be provided to families at 80% of the median income. However, rents need to be capped at 60%. So this developer believes that they should get a better deal and be allowed to increase the rents on moderate income families to 80%, even though state regulations only provide for 60%. Municipalities can't go beyond that, except for limited circumstances where you can reach 70% under certain circumstances that don't apply to Hopes Crossing. That is what the developer's asking for that cannot be met.
But us putting this other zone in place may bring them back to the table once they know that we have an alternative.
Okay.
Is that correct?
Okay, so can I ask a follow-up question? How, was there any other part of the plan with Hopes Crossing besides, like, were you extending, were you giving them a pilot? Were you giving them other, was part of the $9 million trust fund going towards preserving units to them?
So the structure that was provided and that was negotiated and reached was that there would be a consideration of a pilot by the council at their discretion. There would be the forgiveness of township loans.
How many loans too?
Excuse me? And county loans. And the reason for that is if a developer is going to restrict rents for 30 years, they come to the table trying to find a way to make that financially feasible. So the borough did make commitments to try to get those units protected for another 30 years. And the 30 years is not something the township just came up with, it's what's actually required by the statute. So, yes.
Okay. So is some of the $9 million affordable trust money, is that now not all going to be used because it's not all going to go towards crossing?
I'm going to pause before answering that to reference one item on that list. So the monetary contribution that is going to be given to Hopes Crossing was the township loan forgiveness. So the monies that would have been given to Hopes Crossing were not coming out of the Affordable Housing Trust Fund, they were coming through the forgiveness of loans.
Thank you.
And to just put a fine point on that, the agreements that cover those loans don't necessarily come due today. They don't necessarily come due tomorrow. So it's not clear when those monies come in for Hopes Crossing.
I just, as I was listening here, I was just thinking, like, what a shame it is that this is the result of that negotiation. That there's no way to go back to the table to avoid the wasting of this open space that we're trying to preserve and changing its zoning. It's just very disappointing because I feel like maybe it should be revisited. If more money from the Affordable Trust Housing would sweeten the deal for them, just so that we can meet our obligations and still have this open space, or some other kind of negotiating could happen. I just feel like it might be worth it, especially when you have so many people here and, you know, even, I know we don't have time for a referendum vote of the taxpayers, but maybe it's on survey, who knows?
I will just say that there was a lot of effort put into trying to preserve affordability of Hope's Crossing. What the township has done in a number of preservation mechanisms, it has.
Speak up, please.
Sure. So the number of preservation mechanisms you do have is really considerable. And there's a lot of effort into trying to protect Hope's Crossing units.
Yeah. Okay. Well, I wish you luck with that, and I just hope we can revisit it to save this other land. Like, I'm hoping that if that isn't dead yet, so maybe it still has a couple breaths left in it. Can you, on a different note, 186 of affordable units of affordable housing, how many total units of housing do you anticipate that will bring into our town?
What is the number you quoted?
Didn't you say we need 186?
So
Perhaps my notes are wrong.
186
units of affordable housing was the balance after your extensions, controls, and preservation. These are, I'm sorry if I misunderstood, that 186 new units would be built or allowed to be built. So how many total units? Because I know it's just a percentage. Would you anticipate that would?
I think what we put in the plan, and we have a memorandum of understanding, is for a potential 100% affordable 100 unit or 110 unit or something development. Again, there's still the opportunity for Hope's Crossing. The council could also act to help with Hope's Crossing. We've had that discussion as well. It's still an option. We have time where we can amend the plan, as the attorney said. I, for one, would like to protect the senior citizens that are living in Hope's Crossing who are going to lose their affordable units. I had let that be known to the council. I would love it if they would take me up on something as far as working to those folks.
I'm sorry, I still didn't get a number.
It's 100 unit difference. 100 and some
No,
unit difference. So
I don't know that. My question is, if 186 units, affordable housing units are being built, that doesn't account for all of the buildings. I would like to know what your predicted total housing units that are going to be added to the town are to get to the 186 additional affordable housing units.
I understand the question. So the plan identifies what the set-asides are, and I believe it's approximately 600 to 700 units across the projects.
Okay, thank you. I have just one more thing I would love if
Just
you could.
one item, sorry.
Okay, second.
So what's important to recognize, two items. First, that those units are absorbed over the 10-year period as the projects are built. That's one. Two, the set-asides that are added into the plan reflect what you actually have across town, which is when developers want to build, they have to build 20% affordable units. So we match that.
They can do more things.
But that's
yes, the developer could do more if they'd like to build more affordable things.
Mr. Roberts said that there is one.
Jamestown is 47% affordable, something like 44. Jamestown is a much higher ratio. It's nearly half right now.
But typically, when you're building a new one, I'm sure you want to stick to the 20% because of the cost and things like that.
that's, I mean, you're,
I
the reason is, it's not that towns don't want to capture higher 20% set-asides, it's that a lot of developers are not going to come to the table at higher set-asides unless
Because they're
they...
in business to make, I get it. They want to make money, they want to make a profit.
Let me just add one qualification, just because you seem diligent, and you'll probably run the numbers when you get home, and I just don't want there to be a...
Thank you, I am.
Right, I don't want there to be a question. If you look at Jamestown, we list a 30% set-aside, which you might think, oh, well, that's generating more, that's generating, if you calculate a 30% set-aside, the Jamestown is comprised of 20% set-aside. It's also, we're utilizing existing units at Jamestown, so a part of that 42 is comprised of existing market rates that we've had a developer commit to convert to affordables.
Okay.
Just when you're running that.
And then just the last thing I think would be great, and I think everyone would appreciate, is if you can just talk about, and it might even be all of them, but how many of these developers or, you know, housing owners and providers are getting pilot programs, and if perhaps you know the difference in the tax rateable that it would have been to the amounts on their pilots.
So what I can do is answer it in this way. I don't know the rateables, but I'll answer it in two items. One, pilots need to come before the council for approval. Second, in order, the amended FHA has a provision that says if you're looking for bonus credits, you need to provide, there has to be contributions. And so one of the ways you satisfy that contribution is through a pilot. When you look at the housing element fair share plan, the amendment, it will specify the projects that have a pilot mechanism.
Anything that's getting a pilot is something that has a pilot already, so it's like an extension of the pilot. So if you already have a pilot and you were looking for an extension of the pilot to preserve those units, in some cases that was what was done, but no one was given a new pilot who didn't have a pilot before. And again, this is only for the units that we are preserving for an additional 30 years.
So any new units being built are not getting pilot?
No, there's no pilot in any of that. Am I correct on that? Rick, Mr. Hunt? I don't think there's any pilot offered on any of the new construction.
There's one, go ahead.
Jamestown, which has a conversion element, so market to affordable, that has a discretionary pilot component to it. But your other new construction projects, Route 70,
All tax.
yeah.
Full tax.
Okay, thank you.
Thank you.
Raise your right hand, please. Swear to tell the truth, whole truth, nothing but the truth.
I do.
Get your name spelled for the record, please.
Maria Lee, L-E-E. I've been a 14-year resident of Toms River, 14-year resident of Lake Ridge, and over the years, seen the inevitable development and building in that part of North Dover that has occurred through various administrations. I can say that as a former zoning board member of a North Jersey municipality, I understand your role, I understand the role of the zoning board, and I understand the Mount Laurel law and the predicament that you folks are in, just as Mr. Messina had said. It's something that we have to meet the obligation, but it's a tricky point and it's difficult to make everyone happy. What I'd like to point out is my opinion that the Route 70 parcel of this agreement that was made, targeted for development with the affordable housing component, may try to meet the obligations that you are under the gun to meet. However, it really isn't an appropriate plot of land, and it was actually mentioned by one of these gentlemen here that they look for access, environment, and I would like to add traffic. And I think that it does not meet the criteria for all three of those components. Over the years that I've lived in Lake Ridge, there have been various attempts to purchase that piece of property. The for sale sign has been there for 14 years and perhaps who knows how long before that. Apparently, no one has been able to purchase it and successfully come up with a plan because it is a problematic piece of property for a variety of reasons. The egress certainly is one of them, and now with the traffic and the fact that the corner is quite dangerous, it's only exacerbated that. Not to say that it's not ever going to be developed, I'm sure it will, but the more appropriate, perhaps, venue for something of that on that point is a standalone bank or something of that nature, which has never happened. I would ask the board this evening to give consideration to those components and to the fact that it will quite negatively impact the quality of life and the safety in our area. Thank you.
Thank you.
Raise your right hand, please. Swear to tell the truth, the whole truth, nothing but the truth.
I do.
State your name for the record, please.
Tom Madison, 1520 Silverton Road. I'd like to ask Lori, you said we were talking about forgiving the loan, the Hopes Crossing? Loan forgiveness? What was the amount of the loan? Do you have any idea?
There are multiple loans. There's both a county loan and there are also township loans. So basically, these were monies that were provided by the state. They passed through the township in 1994 in order to make that in order to make the Hopes Crossing development possible. So there are multiple loans.
If you're unaware of the number, I do remember the $2. If Mr. Robinson, I think the county, I want to say the county, if the mortgage goes all the way to term, would have been $20 million, and sometime around now would have been $5 or $6 million. And I believe I was told that on a township loan right now will be 3 or 4. It's my understanding. I'm not 100% sure, but the attorney is here as well, that these mortgages were structured like balloon mortgages, and they have to pay them at the end, correct?
So, and what we're talking about was about $9 million?
Yeah, it was crazy that they didn't want to take the money.
Give to extend the pilot?
No, to keep those 100 units affordable, to keep those seniors and disabled folks in that housing, and to get the credits. So we were willing to forgive the loans, but even that wasn't enough.
Well, were we going to add money on top of that?
So Councilman, I believe it's
Affordable Housing Trust Fund? Yes.
Councilman, so I think what I can explain is, in the housing amendment, we actually identified the amount of the township loan, and I want to explain why the number was reasonable, why forgiveness is reasonable. That number is $1.244 million with interest on top. The reason why that number is affordable is under the amended housing amendment, under the amended FHA, there needs to be a contribution there needs to be a financial contribution to the developer. That's what the law says. And so the forgiving the loan was considered to be of equal value to what would be required under the law if you were simply extending. There has to be a contribution given to get your bonus credits, or just to have your extensions. So that was the idea behind the loan forgiveness, to make the extensions viable.
Okay, I've been asking for proof or paperwork or even a contact person to see that Hopes Crossing did actually drop out of this. I haven't seen it. I've been asking for months since it was stated that they dropped out. Now, I've been reaching out to Penrose Corporation myself, and nobody has gotten back to me. I'd like at least a contact person so I could find out for myself if indeed they've dropped out, or maybe they've dropped out, but we're looking to revisit it. Maybe we can take some more money out of this trust fund to get Hopes Crossing back on board. Now, on another note, the original Mount Laurel Doctrine does provide for the repurposing of commercial buildings and shopping centers, office buildings, various vacant properties. Maybe we should look into that before we use up some of our precious land and just liberate more trees. And you did say yourself that we could get an extension on this. I say we apply for an extension.
But I think my words certainly recognize it was, legally what I can say is the ability to get extensions is remarkably hard across the state right now.
That's not
And
what you
no. What I said was if a municipality can actually get an extension, then yes, you certainly could go beyond the March 15th deadline. So that was accurate. The qualification I'm adding, or the color I'm adding for your benefit, the public, is that I know, but you don't take my word for it. Look at dockets around the state. Municipalities have been requesting these extensions and are being denied them. So what I said was accurate. The color I'm providing is the difficulty is remarkable.
Well, maybe with the publicity that this is having on our town, I'm sure some of the state entities will probably catch up on it. Maybe we could get an extension. And one last crazy thing, maybe the towns could band together and we could revisit the builder's remedy, maybe sue the state and get that thing so it's not scaring so many people. Has anybody ever thought of that or tried that?
I'll just say this all in court. So there are a band of countless municipalities across the state that brought a lawsuit in Superior Court. It was eventually brought up to the federal courts, and they lost in each one of those jurisdictions. I understand this has been around since the 80s. This has gone to the Supreme Court. I'm amazed I've been practicing for 7 years. When I started out, I looked at dockets, and I could not imagine how so much litigation can be generated from this context. But builder remedies have been around and protected by the courts since the 80s. But I understand your policy on that for sure.
All right, thank you.
Please, swear to tell the truth, whole truth, and swear the truth.
Yes, I do.
State your name, please, and spell for the record.
Phil Brilliant, B-R-I-L-L-I-A-N-T. Mr. Chairman, just a question for the general question. This right now is a Q&A, information, and then you're going to go to a vote. There was no agenda, so I'm just trying to... Yes. What is going to be the process here? Once we're finished with the questions from the public, we will vote on the referendums that we have in front of us. Okay, and everything, and then at the end is public comment again? Or is this the public comment period?
This is a public hearing on, what happens here is that these ordinances and the other matters that are before the board here are for the review to make sure that they are in compliance and with the master plan and with what Affordable Housing Council needs to make sure that these things are put in place to preserve the builder's remedy. The actual vote on the ordinance will happen before council.
Tomorrow
So,
night, right?
yeah, okay, so this is a review and recommendation from the planning board, but no action comes, nothing of any import as far as getting enacted happens tonight. This is a review period and a recommendation.
Except for the fact that, I'm assuming one of the ordinances or whatever it's called here, planning board, is going to change the master plan if Tom's true.
The affordable housing attorney is more able to tell you what's in the ordinance.
Mr. Attorney.
So in June 2025, there's a housing element, there's a fair share plan, there's a housing element and fair share plan adopted, and then it's a master plan. Tonight, before the planning board, there are two items, both the recommendation to the Township Council on the overlay zoning and also the adoption of the amendment to the housing element and fair share plan, which, yes, amends the master plan.
Yeah, so basically, the votes tonight will change the zoning in any of the properties that are included in the affordable, like the ones by Route 70, which are now, I think, rural highway business, would become MF-18? I'm sorry.
No. So an amendment to the master plan sets out the policy vision. The ordinances themselves enact the zoning, and as council has identified, that is before the Township Council tomorrow.
Okay. So this is strictly recommendations to the council for tomorrow night.
That's one part, and then the housing element and fair share plan, that's the policy document. It is not in fact zoning, it is just, this is the amendment to the master plan setting up the vision for how you achieve affordable housing.
Okay, yeah, good, thank you very much. And, okay, so that answers that question. Yeah, I know there's been a lot talked about, and I don't want to go over numbers and everything like that, but I think you've covered it. My question is, on the, say, Hope Crossing, they're gone. Okay, to say for lack of a better term, you can't come to an agreement. It sounds like there still could be some negotiations, whatever it might be.
And we're talking about these 2 lots on Route 9 that are part of the affordable recommendation. Is there a number that, I'm assuming it's not 1 for 1. If Hope's Crossing was worth this, what is needed on Route 9 to match those?
It's like, it would have to be the development that would go there would have to be 100% affordable so that we would get that match.
Right.
Because Hope's Crossing is a 1 for 1, and that's what we go there, and there are interested parties in providing that should Hope's Crossing fall through.
So, and one additional item there, Hope's Crossing was a 110-unit project. It did not necessarily generate 110 additional bonus credits because we were capped pursuant to the law on the number of bonuses we could get. So it's 110 plus 80, approximately 83. So when you go to replace Hope's Crossing, you have to make sure that you can't just do 83 units and double. You have to actually make sure you're meeting your cap. So it's 110. Usually it's 1 for 1. In our case, we had to do 110 and 83 because we were capped in the number of bonuses we could generate.
So are you saying, simple terms, sorry, simple
I'm
one.
sorry.
Yeah, it's fine, you can stay in the weeds, we'll figure this out. So you're at 193 units on the 2 lots on Route 9? If you just said 110 and 83?
Apologize. 110 units, and you get 83 additional just.
They're not real
credits.
units, they're just credits. Yeah, so you do 100% affordable, they credit you 2 units for each unit.
So
And that's,
110 units. So the simple answer is 110
it
units.
would be 100, right, you'd be replacing Hope's Crossing with a Hope's Crossing.
And just a question on the settlement, in that spreadsheet that's in there, when it talks about Hope's Crossing, it's got, 3 columns, it comes to a total of something 93, I can't remember what the number was, but then next to it says 125 actual units. And you just threw out 110. What is the 100? I've always wondered, what is that 125 actual?
Basically, that means that the project had 125 units, and we only needed to capture 110 units to meet our obligation. If the developer de-restricted all 125, then there would be additional units we could utilize for the future. So there are 125 units in the project. We only need 110 to satisfy our obligation.
So this Hope's Crossing has great value to us. It could eliminate any development on Route 9, that we have to go back for. And I'll hold that question for a second. And then, aren't there other affordable housing properties throughout Toms River that we could go back to possibly lessen the multifamily 18 requirement and the 20, whatever, 600 units you just said, you got next to Lake Ridge? Is there somebody else we can go back to or some way? And I'm going to tie that into, I understand March 15th is the deadline. It appears that Toms River has gone above and beyond the Call of Duty good faith efforts. I would have to think that has some weight. I know you said everybody gets denied, but you had somebody pull out after it was approved, you didn't expect that. I'd have to think that it's worth, it appears, at least for over a year and a half, if not 2 years, the mayor with council and experts have fought on this. I just think we shouldn't stop fighting.
Well, we did attempt to capture everything that expired, right? So anything that was built in round 1 would have been expiring now. Some stuff in round 2 that was 20 years, and anything that was available that we bought. And then we were left with that 186 number. As far as finding more, I would love to. I would love to figure out a way with the council to preserve Hope's Crossing. We did have that conversation as a council.
What do you mean preserve Hope's Crossing?
I would like to figure out how to keep Hope's Crossing there. So in case it falls through, I would like to do whatever it takes to keep Hope's Crossing.
So just one item you were saying, can you go to other projects in town? One of the items that's so difficult is that when you're trying to find mechanisms and developers, finding developers who will do 100% affordable project can be difficult. The great thing about it is if you can find it, you get bonus credits, and you minimize the maximum number of units. If you go to other developers who say we want to do inclusionary, we don't want to do 100% affordable, you end up with far more units. I don't.
So can I add one thing? Do you know how difficult this is? You're asking in an era of ultra inflation, everything is so expensive, right? And you're asking a developer, okay, build now, and it's so expensive, but by the way, we're going to give you rents from like the 70s. You know, I mean, that's really what it comes down to.
But if I'm understanding what I'm saying, is I'm not talking about build now. Okay, I'm talking about the ones that are already built.
Yeah,
Back
we
to-
could keep.
But because the build now one, what I just heard tonight, and I'm a little surprised, but what I heard was that we have, in our affordable housing plan, a development on Massachusetts and Route 70, which is gonna produce 140 or something like that units, I can't remember the exact number, of affordable, 20%, that is, could possibly have units on Route 9 from the same developer, because I think I saw it looks like it is the same developer, and no pilot. That blows my mind, by the way. And if that's really the issue, then that is a phenomenal deal for Toms River. I just find it hard to believe that somebody's willing to build 100% affordable on Route 9 and not demand a pilot. That's.
Well, I just want to jump in. There is nothing set up, right? So each of these things, I'd like to circle back. We have, I lost my train of thought, that's awful. I've been at this now since today. Normally loses lots of words.
Can I ask the attorney a question? If we're able to get Hope's Crossing back into the fold after the 15th, can we then revisit this to try to get the leisure, what everybody's here for, out of the equation?
That wouldn't, no, unless we did 100% affordable anyway on 9, and even then, I don't think that's, well, yes, that would do it, that would potentially do it. If we had 100% affordable on 9.
So what I'm saying is, at this late date to try to get the extension, it's going to be really a problem, because as much as people don't like this project, be careful what may be shoved down our throat by the state of New Jersey.
And I definitely understand that. I just got one more question. In the revised plan, which again, just by resolution at the last council meeting, where it talks about Hope's Crossing coming out and the 2 lots on Route 9, the overlay includes like 60 additional acres, okay? Which are not part of any affordable housing plan I've seen. They're owned by Toms River Township. They've been preserved for open space. Why would we even be bringing those to the table right now to rezone those as multifamily?
It was Rick Hunt's thought to have a backup plan. Should anything else fall through, should the development at Lake Bridge or near Lake Bridge not go through, should the developer not move forward, there would be another location for those units. That was the entire purpose of the overlay, at least that's my understanding. Am I correct, Rick?
He threw it on the attorney, but he doesn't ask you, Rick. I'm just saying.
Either of them, this was
He said the attorney's plan, but
this goes on.
This parcel was, presented by the township, that it was owned and it could potentially provide the opportunity for affordable housing. Our hope is, I would just state that Hope's Crossing still is in the plan. They have not been taken out of the plan.
Correct.
So I think that's important to note here, that our plan submitted to the state does include them. So hopefully, this brings them back to the table. And in the event, we need a compliant plan. So we've, the Route 70 site, that was a part of the mediation agreement, so that, there was no taking that out. And we're just, identifying mechanisms that can satisfy the state's obligation.
Respect the idea, hate the idea. So that's it. Thank you very much.
Please come forward, raise your right hand. Swear to tell the truth, whole truth, nothing but the truth.
I do.
Please state your name and stop the record.
Mauricio, 300 Woodview Court, Township, New Jersey. I have a question. Toms River in rounds 1, 2, and 3 has been tasked with 3,200 units of affordable housing. Do those go in perpetuity, or after 30 years is that obligation erased?
Your obligations carry on into the future. However, if you satisfy portions of them, then it's the remaining portion that continues into the future. This is what municipalities across the state deal with.
All right, just as an example, 10 years ago you could buy a home in Holiday City for under $100,000. Now it's $350,000 or $400,000, and that's a senior community. Kim's right. The problem is what housing costs, period. But I just have a tough time recognizing how when you have Lakewood, Toms River, and Brick, 350,000 people connected by a state highway system of single-lane roads, that you're going to be able to move traffic on not. We preserved that land in 2017. We rezoned it as rural highway business, so that we didn't have the intense development of PDUs, planned urban developments, because it was getting out of control. We have Gabriel Run out there that's 375 units, 75 units of which are affordable. At some point, enough is enough. I mean, where are you building affordable housing in Spring Lake at Belmar? I realize they don't have land, but I challenge you to find land in Toms River that's not township owned, that's owned by a developer that's going to build all these units. You can't move around here. I've lived my entire life in Ocean County. And if you live south of the Raritan River, you're going to lose school aid, you're not going to get transportation infrastructure, and you're going to get affordable housing up to Yin Yang. So at some point in time, Trenton has got to pay attention to the people in Ocean County. There's almost 700,000 people. This isn't when I was in high school in the 60s, where Lakewood was 10,000 and Toms River was 8,000. These are major cities, and the state has not addressed the infrastructure, and yet they're going to plow more affordable housing into these areas and try to shoehorn it in where it doesn't fit. My attitude is, fight it. Come down here, have Governor Sherrill come down here and tell me where we're going to build it. Find open land that's not owned by the town. We went out and bought it to preserve it as open space. You're going to take and put 100 units in there. And that's only the beginning. If I look at it right, you can build that whole area out at MF-16, which is the most intense development in this township, on a highway that's one lane. That's one lane. Show me that north of the Raritan River, where you've got 350,000 people in 3 towns connected by state highways that are single-lane roads.
My name is Robert Knight. I'm a Toms River resident. I've been down here for about 30 years. And I don't offer any solutions. I don't think there are solutions. There are only choices. And what we've been faced with now with the state of New Jersey mandating this is a lot of bad choices. Route 9, rezoning, it may be what it comes down to, but it's going to be a problem because as the gentleman just said, that road does not handle all the traffic that's on it now. Addition to that, you're going to take away potential additional ratables and turn them into residential housing, which historically has much lower tax base.
This is not, it's not a rateable. The backup plan is township-owned property, so it's not a rateable currently.
But are they not commercially zoned now?
It's commercially zoned right now,
so potentially it's a higher
owned by the town, so there's nobody paying taxes.
Okay.
And it's only a backup plan at this point.
I understand.
If something like Lake Ridge were to fall through,
right,
you'd have to replace those units.
The other issue we've got, as Kim mentioned, is how are you going to get a developer to
build new construction and maintain rentals that are at 1970s rates. That's going to be a challenge. So I don't have a solution. This is something we're faced with because of the state of New Jersey. They're putting, and as that gentleman just said, you've got Toms River, Brick, and Lakewood with a huge population base, and they're shoehorning us into this. And I just ask you all to consider that and make a wise choice. Thank you.
This is New Jersey doing this. This isn't Toms River doing it to ourselves. This is the state of New Jersey forcing us to do this. None of us are happy about this.
And I understand.
Thank you. Yes, please come forward.
Just state your name again, you're still in the room.
Yes, Janet Lynch. I still from Stilltree. Just something that came up in a question I was asked after me. Because this is a zoning ordinance, was every property owner within 200 feet of the affected areas given proper notice via personal service, certified mail, or email with confirmation as required by NJSA 40:55B-15?
So the second reading of the zoning ordinance for tomorrow, notice was provided to property owners within 200 feet and within the zones.
Is anyone that's here within 200 feet of the affected area that got a notice?
No.
Did anyone get a notice?
One person does.
One person got a notice?
I got it.
You got a notice?
Your house has to be
Within 200 feet?
right. So the folks on the back side, like the lady on the far left over here, she received a notice because she backs up to the property. She's in like the last block.
I just know this wasn't done before, and we lost in court, so I don't want to have to.
Yeah, we should have had that fifth vote.
I don't want us to incur more unnecessary litigation that we lose, because clearly outlined procedures and followed. There's two things that weren't followed. That was also a zoning ordinance, and I just don't know if everyone here that lives within a property or the areas that are going to be affected know that a petition signed by the property owners of 20% of the area affected by a proposed zone change, or the property owners of 20% zone change is filed with the municipal clerk. If you oppose it, you get 20% of property owners that oppose the change of zoning within that area, and you submit it to the municipal clerk before the vote. They need a 2/3 vote, which is a supermajority, correct? Also, if the ordinance is passed, there's a period called estoppel. There's an estoppel period. So you have 21 days to collect petition that would have, approximately 4,000 signatures. I would have to look up the most recent registered voters list to give you the exact number. But if you get those signatures, then the power is within the residents of Toms River and not with the council or the planning board. State your name and for the record.
Yes, I'd just like to ask you one question. I hope everybody's listening. On our property tax, we pay $100 for open space. I don't know, half these people don't know that. Can you please explain to me what that is, and why are you developing on open land?
I can answer what the open space levy is, but it's not, excuse me, I'm trying to answer you.
Okay.
I'm a planning board attorney, but I do municipal work, and I know that an open space levy is assessed by statute, and there's an ordinance that the council had to have adopted for them to assess a levy for open space. That's what that's about.
Okay, so we're paying $90,000 for you to maintain that space. Thank you.
No, we're the planning board, not the town council. We don't pass the taxes on.
Raise your right hand, please.
Paid through our taxes.
Swear to tell the truth, whole truth, nothing but the truth.
Yes, ma'am.
State your name and spell for the record, please.
Carlos Anzar. Carlos Carlos Anzar is Almanzar. For attorney, the time has spoken. I guess I know it's going to be a headache, but just get going and submit and see if we could get an extension on it. I know it's going to be hard. I know you got a lot of work and you got other townships, but try it. Now, there is another solution. There is more land in our town that we could try to go for. Mayor, down the street there's, we already got affordable housing where I'm at. That area, there's a nice lot. I don't know who owns it, I don't know, but that is a nice lot where we could, instead of that, implement those instead of building, because I know there's going to be built soon in that area. So I think about building in that area. You got the Winterham's project, and then you got the other complex that I don't know their name, and then you got ShopRite. That piece of land in there, it's nice and big. I think it could give you the number that you guys need. But like I said before, 270, I've done business in there, and I have actually saved 3 different scenario accidents where people almost died because of the accident, especially right in that corner.
Raise your right hand, please. Tell the truth. Swear to tell the truth, whole truth, nothing but the truth.
Yes, I do.
Please state your name and spell for the record.
First name Paul, last name Williams, W-I-L-L-I-A-M-S. I heard I repeatedly heard comments about, this is coming out of Trenton, this is coming out of Trenton. So I wanted to ask the attorney if he could elaborate for myself and for everybody else, people in the panel, how did this come out of Trenton? What prompted Trenton to enact this legislation?
Sure. So in the 1970s, there is a lawsuit. There's a Supreme Court decision that recognizes that municipalities have an obligation coming out of the Constitution to zone, to provide the opportunity for moderate and low-income housing creation. That doctrine has been developed over the course of decades in multiple Mount Laurel lawsuits. It's recognized by the court that there's a constitutional obligation. So the bill that came out of Trenton in 2024 modified the structure from the 3rd round, recognizing that the courts have found that this obligation exists. So the new bill responded to what has been a doctrine in place for decades, that municipalities need to meet a certain number, need to provide a certain number of affordable units over the course of a 10-year period, a 10-year housing cycle.
And so would you agree with me that this lawsuit that started in 70s, early 80s, legislation finally comes in 2024?
No. Sorry, go ahead.
The one that you referenced, there was some legislation in between that, correct?
There's been a Fair Housing Act, there's been a number of different.
And would you agree with me that the reason for that is because the Supreme Court decision came out recognizing that there's a constitutional obligation to provide the opportunity for fair housing. There was some legislation, it wasn't working, another lawsuit was brought, again, re-emphasizing the original Mount Laurel decision. Again, it didn't work out. Again, there's some more litigation. And this is, candidly, if you agree with me, something that's just very difficult to implement where everybody's going to be happy, correct?
I think that's a fair statement.
So here we are today, and there's a difficult decision that this panel has to make when they're about to make their recommendations. However, I can acknowledge that it's difficult, but what you've been presented with today is essentially an amendment from a settlement in December, where you now have acres of township-owned property that is going to be developed. If your recommendation is that, and the council, adopts it. But to the attorney, are you familiar, can you advise us all, how the township came to own that property?
Cannot.
I'm going to do something I'd rather not, but through the chair, if Mayor Roderick would like to answer that question.
I voted with the council when Mo acquired the land. The land, several lots that had little tiny houses on it were demolished recently, along with every structure that the town owned that was unsafe. Your statement that this property will be developed, that is not accurate either. It's a backup plan should one of the other units, one of the developments, whether it be the Lake Ridge, the place where the folks, Route 70, where the folks at Lake Ridge.
But I didn't ask you, no, but I didn't ask you that. That's not what I asked. I asked you if you could tell us how the township came to own that property.
I just did, we voted and acquired it.
You voted and acquired it, but you personally were opposed to it, correct?
No, I voted for it.
You didn't say, and you didn't tell the news media that you didn't think that $10 million, in fact, $10.3 million was the way the taxpayer dollars should have been used?
I don't recall saying that, but I'll go back and check. I'm pretty confident I voted for all open space purchases throughout my tenure on council. It would have been not like me to vote against some open space. I supported that when Mo wanted to increase the open space tax and wanted a referendum. I supported Mo on that as well.
That's not what I'm asking you.
No, but it is.
No, but it's not. I'm asking you.
Okay, I don't want to argue with you, Paul. So you have my answer.
So the point that I'm getting at, because
but I do want to clarify that this property is not
Mr. Roderick has this propensity to talk over people and insert things that are not relevant to the question. And so the point to my question is this. I recall 10 years ago, approximately 9-10 years ago, when Mr. Roderick, who was a Democrat at the time, was a candidate for council, running as a Democrat, was outspoken against this land being purchased by the township. The township purchased it, not using the land use funds, but I think it was out of a general fund. So this isn't even protected land, because the word of the council, when it expended taxpayers' money, is going to be dirt if that property winds up being developed on. Because $10 million of taxpayer money was used to purchase that explicitly with the intent of it being preserved and not developed on. Here we are now, when it appears that the Hope Chapel, the Hope Crossing development might not be there. Now it's a new pivot, a new creative thing, which was Roderick's phrase last year, creative thinking, because that's what he is. He thinks he's creative. But now when it's not convenient, now all of a sudden he wants to push it, and push it so much that he's sitting on this dais tonight. He wants to make sure that vote goes through.
The thing is, it's relevant.
It is relevant.
It's not relevant.
And it's my time, and the chair hasn't said it's not relevant.
To the decision we have to make.
Yeah.
It has no bearing on us.
I disagree with you. I disagree with you.
If you wish to.
I disagree with you, and it's my time.
Let him speak. Continue, Paul.
So as I was saying, it's a horrible idea, but so is a lot of decisions that you have to be made. But I just want to make sure that we're clear about this one. That Dan Roderick is the proponent for something that he was once so ardently against. So ardently against. And now he's sitting there on a dais to make sure that what he wants, so he can brag again about his victory. Just keep that in mind. When you're about to make your recommendation to our council, and our council is under the gun, they got to make a decision tomorrow. And unless someone says, you know what, we're going to hold off. We are going to ask our council
to seek an extension, no matter how difficult that may be. There is a legitimate argument to be made that there was an unforeseen circumstance where the developers at Hope Crossing pulled out, unanticipated, nothing we could have done about it. We need a little bit more time, for Mr. Roderick and his administration and all their brilliance, I'm sorry, folks, to revisit Hope's Crossing. But right now, this board has a difficult decision, and I acknowledge that. But I just want to make sure that you are all clear on that topic about Mr. Roderick. Thank you.
Is there anyone else that would like to come up with comment? Seeing none, motion to close that portion.
Second.
So all in favor?
Aye. So
Chris, from the standpoint of these individually, I'm just going to recommend that they review it and make a motion. You don't need anything more formal than that? And, roll call. Okay. So what I would do is just go through each one of these and just
Okay. Number one, an ordinance implementing site-specific and area-specific zoning provisions. I'm sorry.
We need to make a motion in regards to the affordable housing element. We need to make a motion to adopt. To adopt the amended housing element in the fair share plan. Then we go on to the ordinances.
Motion.
So, Mr. Chairman, I want to make a motion to approve the resolution adopting the fair share plan. I do want to make a few comments about this, because obviously, look, there's differences in this town politically, but we're losing sight of the forest. Our difficulty here is not within us. Our difficulty is with the state of New Jersey. We are being railroaded because they think you have too much and they want to give it to other people. That's why we're here. You have things that we should give to other people. Maybe they're unfortunate, maybe they want to work, maybe they don't want to work. But the end result is get used to it. Because as long as you're going to be living in the state of New Jersey, they're going to take it away from you. All right? And the end result is, it wouldn't surprise me. I don't think anybody in this room is going to be alive when it happens, but it wouldn't surprise me down the road that they make people that can't afford housing take your bedroom and you can sleep on the couch. All right? Because that's where we're going. If you went back 50 years ago and thought we were going to have this discussion about making people be able to buy homes from prices that went back to the 50s and 60s and 70s for today's prices, it would have been unthought of. So I do want to hold my nose to this resolution, resolution to approve, because it's not what any of us want. But the alternative to not approving this, and this is a word of warning to the council, if you don't approve it tomorrow, the end result is you're going to get something that is much less desirable. With that, I make a motion to approve the resolution.
Please stop. I have to take care of stuff right now, please. Okay, I have a motion to adopt the resolution for the amended housing element. I need a second.
I'll second.
I'm sorry, who was that? Thank you. Mr. Pasquarello?
Yes.
Mr. Fenchel?
Yes.
Mayor Roderick?
Yes.
Mr. Bradley?
No.
Mr. Brack?
Yes.
Mr. Watson?
Yes.
Mr. Nazardo?
Yes.
5 votes to adopt the resolution and the housing element.
Okay, we move on to the ordinances. Ordinance implementing site-specific and area-specific zoning provisions to effectuate the township's fourth round housing element and fair share plan. Motion?
Mr. Chairman, I make a motion to make that recommendation to the Township Council.
Second.
Mr. Pascarella?
Yes.
Mr. Fetchel?
Yes.
Mayor Roderick?
Yes.
Clint Bradley?
No.
Mr. Pratt?
Yes.
Mr. Watson?
Yes.
Mr. Nazardo?
Yes.
That's 6 votes to recommend the ordinance for adoption.
An ordinance of the Township of Toms River amending Chapter 348-11, Article 11, Affordable Housing Provision of Chapter 348, Land Use and Development Regulations pursuant to newly enacted regulations of the Uniform Housing and Affordability Controls.
Mr. Chairman, I make a motion to make that recommendation to the Township Council.
Second?
I'll second.
Fetchel? Mr. Pascarella?
Yes.
Mr. Fetchel?
Yes.
Mayor Roderick?
Yes.
Mr. Bradley?
No.
Mr. Bratton?
Yes.
Mr. Watson?
Yes.
Mr. Nazardo?
Yes.
That's 6 votes to recommend the ordinance for adoption.
An ordinance of the Township of Toms River designating certain properties as an affordable housing overlay zone with the MF-16 multifamily zone.
Mr. Chairman, I make a motion to make that recommendation to the Township Council.
I'll second.
Mr. Pascarella?
Yes.
Mr. Fetchel?
Yes.
Mayor Roderick?
Yes.
Mr. Bradley?
No.
Mr. Bratton?
Yes.
Mr. Watson?
Yes.
Mr. Nazardo?
Yes.
That's 6 votes to recommend the ordinance to council.
We're done.
Just one other council.
Yes, just for the record, Rick Hunt, Township Planner, that the 3 ordinances that were just approved have been reviewed for consistency with the municipal master plan, and they are consistent with the amended housing element fair share plan.
Thank you, John.
Thank you. We have a motion to close the public comment portion.
Motion.
Second.
All in favor? Aye. Motion to close?
I'll second.
All in favor? Aye.
Well, Jennifer, it's fine. I never have anybody keep